There are a number of ethical and regulatory issues thrown up by third-party funding. The first of these really relates to the very conduct and control of the case. In the traditional marriage, there are only two parties, the lawyer and the client, in this context, the claimant. But the intrusion of a third party in the marriage, in the form of the funder, does give rise to complication because, of course, the lawyer's duty is very much to the client. But given the interest of funders in the merits, they obviously want or would like to be involved in the major tactical decisions. They want to have access to at least some of the documents. And of course, the question of access to documents gives rise to potential questions of waiver of privilege and confidentiality. And all of those potential issues have to be ironed out in the contractual terms between the funder and the claimant. There are also, of course, a number of possibilities where the interests of the claimant and the funder may diverge. The one which arises most frequently is the context of settlement or compromise. If an offer of settlement is made, it's not uncommon for the funder to find it attractive because the funder is looking at the whole thing as a business proposition and wants to recoup its stake or cut its losses. The claimant, on the other hand, may want to hold out for more. And likewise, if there's a perceived change in the merits or the prospects of success and the funder wants to quit, that can give rise to difficulties. And all of those matters have to be refereed according to a careful mechanism included in the contractual provisions. On the subject of conflicts of interest, of course, that other dimension can give rise to problems with the tribunal itself, because, of course, if one of the members of an arbitral tribunal has some sort of pre-existing relationship with the funder, then that's as much of a concern as if that member of the tribunal had had a relationship with one of the parties. Of course, that sort of thing can only be discovered if the claimant is obliged to disclose the fact that the claimant is in receipt of funding. And that in turn gives rise to yet another ethical issue, which hasn't been fully worked out. Does the claimant have an obligation to disclose to the tribunal or to the opposition the fact that he's in receipt of funding? And certainly the trend in most jurisdictions is towards an obligation of disclosure. And that does appear to be the right course because the involvement of third-party funding inevitably gives rise to an adjustment in terms of whether the playing field is level. Because of the advantages of third-party funding, the claimant is in a pretty solid position, which in many ways gives him an advantage over his opponent in the case. And of course, that in turn throws up issues of security for costs, whether the other side can seek an order for security costs against the funder itself. In Hong Kong, the view appears to have been taken that that can't happen, at least in the immediate term, because of course the funder is not a party to the proceedings and the machinery doesn't currently exist for an order for security for costs to be made against the funder.